And secondly, good morning, everyone. Welcome to the Licensing Act 2003 Subcommittee meeting on today, the 1st of July 2025. Declarations of interest, please.
It's just from yourselves, Chairman.
Oh, okay. Minutes of the subcommittee held on the 13th of March. We've read those, agree those? Yes, thank you. Agenda item number 3, the main item, is the application made under Section 17 of the Licensing Act 2003, the Black Sheep, 26 to 27 Prince Street, Bridlington. I have a little list of things to state, first of all. These proceedings are being recorded, and in the event of an appeal to the Magistrates' Court, a transcript will be provided to the court. Please bear in mind that whilst this is not a court of law, all parties will be given a fair hearing. All parties have had a copy of the procedure, which will be adhered to. Please would all parties state their name and why they are present for the purpose of this recording. I can say that my name is Councillor John Dennis, and I'm the chairman of this subcommittee today.
Councillor Jonathan Bibb, subcommittee member.
Councillor John Boville, subcommittee member.
Carolyn Ashton, legal advisor to the subcommittee.
Louise Wilson, Health, Safety and Licensed Services Manager, here on behalf of the Licensing Authority.
Faye Glasgow, Principal Health, Safety and Licensing Officer, representing the Licensing Authority.
Donna Wright, I'm here on behalf of Andrea Pinder, making a representation. Sue Wright, here making a representation, sorry.
Nicola Castle, applicant.
Morning, Alex Green, Gostrok Solicitors on behalf of the applicant.
John Wiley, committee manager to the committee.
Thank you. I can confirm that members have read all the documents provided by the parties. Further documents will not be accepted unless all parties agree. Are there any additional documents? No, thank you. Do the parties wish to call witnesses? Thank you. Do the parties wish to ask questions of each other?
It's hard to say, Chair, at this stage. Obviously, the opportunity is there, but at this stage,
thank you.
Yeah, I'd like to say, obviously, it's hard to say until we know what's been brought forward by the applicant.
Okay, thank you. The time limits for the hearing are opening statements 3 minutes, evidence from any witness 2 minutes each, questions of any other party or witness 3 minutes, summing up 2 minutes. And we have been noted to be flexible on this if entirely necessary. Are all the parties content with the time limits?
Yeah, I'll do my best, Chair. There or thereabout. I was given 45 minutes at Westminster a couple of weeks ago. I thought that was too long, but yeah, 2 or 3 minutes would be great if possible.
Thank you.
Yeah, that's fine. Thank you very much.
Okay. I now call on the licensing officer for any updates in relation to the application under consideration.
We've got no updates, Chair.
Thank you. Well, the licensing officer now is to outline the application, representations and any relevant part of the licensing policy.
Thank you, Chair. This application was made under Section 17 of the Licensing Act 2003 by Nicola Castle for a new premise licence in respect of the Black Sheep, 26 to 27 Prince Street, Bridlington. The application is shown in full at Appendix 1 of your report. The application is seeking the following licensable activities: sale of alcohol Monday to Thursday 12 till 23:30 hours and Friday and Saturday 12 till 0100 hours and Sunday 12 till 2200 hours on the premises only. Recorded music Monday to Thursday 12 till 23:30 hours and Friday and Saturday 12 till 1 AM. Sunday 12 till 2200 hours. Indoors only. Late night refreshment Monday to Thursday 2300 hours to 23:30 and Friday and Saturday 2300 hours till 1 AM. All activities have a seasonal variation until 1 AM to include bank holidays, Christmas Eve, Boxing Day and New Year's Eve. The applicant has also indicated the following opening hours: Monday to Thursday, 12 till 23:59, and Friday and Saturday, 12 till 01:30, and Sunday, 12 till 22:30. Under the terms of the Live Music Act 2012 and the Deregulation Act 2015, live and recorded music is only a licensable activity between the hours of 2300 hours and 0800 hours for both amplified and unamplified music if the premises is subject to an alcohol licence. The applicant has offered conditions of part of the application as shown at pages 2 and 3 of your report, and members may wish to consider if these are enforceable as written or whether these are statements or duplications of existing legislation. Further advice should be given should members require this. I have also put a copy of the revised condition which all parties should have received. The licensing authority is satisfied that the application has been advertised in accordance with the Act by public notice on the premises, in the local newspaper and on the Council's website. 3 relevant representations were received against the application. All representations were received from relevant persons residing in the locality of the premises. No representations were received from any responsible authority. When representations are received and not withdrawn, this matter must be determined by the Licensing Act 2003 subcommittee, who have the following options available to them as shown at section 5.1 of your report, which are to grant the premise licence as applied for, to grant the premise licence subject to the conditions mentioned in the operating schedule, modified to such an extent as the authority considers necessary for the promotion of the licensing objectives, to exclude from the scope of the premise licence any of the licensable activities to which the application relates, to refuse to specify the designated premise supervisor, to reject the application made. Thank you, Chair.
Thank you. Over to the applicant, if the applicant wishes to make an opening statement or introduce witnesses.
Thank you, Chair. Morning all. I'll be as quick as I can. If it's okay with the committee, I'll go through my submissions in 3 stages. Firstly, I'll tell you a little bit about the applicants and their application. 2, I will explain how the application promotes the licensing objectives. And then finally, I will address the representations received. So the applicants and the application. Well, the applicant, Nicola, well known in Bridlington, been local for over 30 years, heavily involved in family businesses throughout the town, cafes, catering businesses, runs a catering business at Bridlington Rugby Club, for example. Used to running weddings, parties, rugby events, knows how to deal with all the usual challenges one faces when in a licensed premise. The bar on Prince Street, very commercial, central area, many bars, amusements, takeaways, tourist shops, etc. in the area. Unfortunately, the street also has quite a few empty units as well, which is obviously sad to see. The rear of Prince Street kind of fronts over the busy working harbour, many shops catering to all the many visitors passing by throughout the year. The hours sought in the application, as we've heard, far from onerous, especially given the area, numerous licensed premises nearby with much, much later hours. Notwithstanding this fact, it is far from certain that Nicola will even use all these hours, especially earlier in the week, but the application has been made future-proofing reasons and to cover all the many events that happen in the town throughout the year. The bar's been running on temporary event notices since about October, mainly Saturdays, occasional bank holiday weekends, etc., just to give Nicola a chance to get the bar renovated, ready to open, iron out any issues that you'd expect to have. There have been no licensing-related issues whatsoever during the running of the Tens. No complaints relevant to the licensing objectives to the venue or the responsible authorities that we're aware of. The police have popped in on numerous occasions and they're all very positive. The only issues have been personal issues relating to the use of wheelie bins, car parking on private gated land behind the premises. I'd like to remind the committee and the objectors, these issues are not licensing related issues. The premises could open tomorrow, 7 days a week until 11 p.m. as a cafe, unlicensed obviously, and these neighbourly disputes about bins and parking issues would still remain. All we are concerned about today is the granting of a premises licence and any adverse effect on the licensing objectives. How the licensing objectives are promoted here with this application? Well, Very comprehensive operating schedule within the application, as we've seen, and Nicola was given some useful advice and assistance by the licensing police officer as well throughout the process. CCTV, staff training, incident refusal book, challenge 25, risk assessed door staff, signs advising customers to leave quietly, windows, doors to be kept closed during regulated entertainment, music to be switched down during closing, etc., etc. So, onto the representations. Well, firstly, I would ask you to consider the representations against the backdrop of the fact there are no representations from any of the responsible authorities. There were no concerns, no negotiated conditions, nothing. There have been representations relating to 2 of the flats located at the rear of the commercial units, which are located above a row of shops and food shops that overlook the harbour. I think some pictures may have been circulated over the last few days. The rear, I say the rear of these flats, I'm not sure if it's the front or the rear, but the rear compared to the water of these flats face the rear of the commercial units across a kind of private lane in a kind of gated private area. I think a number of these flats are also maybe holiday lets as well. As far as the representations, well, I'll look at flat 6 and kind of group it together because they're kind of obviously related and connected and identical. Public nuisance. The couple who live here concerned about the increase in noise they have experienced since a number of late night venues have opened in the area since lockdown. Nicola's premises, however, have barely been open as they've been running on tens. They've had no issues whatsoever with noise when they have been open. Any noise issues the residents may have experienced are clearly coming from the very late night venues that back into the same area. One of them is open till 4 a.m. and has an outside balcony at the rear. And that's a kind of late night clubby music sort of bar. Our premises has got good soundproofing. There are no windows at the back that open, and there are no rear doors that are regularly opened at all at the rear of the premises near these flats. They are concerned about the potential for disturbance with beer deliveries or barrels being collected, which is fair enough. This won't be an issue, but to put their minds at rest, if the committee was minded to grant the application, we would be absolutely fine with a condition that was to stipulate no drink deliveries / collections to take place between 8 p.m. and 7 a.m. For example, that just puts their minds at rest straight away. There won't be people wheeling barrels around in the middle of the night. So I've got to mention rubbish bins and car parking. Clearly, there have been disagreements relating to who's been using which wheelie bin, where they're located, who is allowed to park where, etc., etc. Well, these aren't licensing matters. I've advised my client to address these with the property agents to clarify who can park where in this private area. Hopefully these fallouts won't carry on because nobody wants it. It's a shame. I understand that Nicola was getting on fine with the guys at flat 6, but then there were falling outs about wheelie bins and who was using them and parking, and it's been a little bit acrimonious since, so respect that. Nicola's partner Gary has been mentioned by I think one of the residents regarding rows with him parking and with rows about parking and bins and stuff. I'm not going to go into too much detail because Gary is not the applicant, he's not the DPS, and he's not involved in running of the business. He's a full-time builder who's been involved in the renovations at the site. I have respectfully suggested to him, even though he's not involved in this and to do the license calculation, I've respectfully advised him to just not get involved in arguments and not get involved. I've also advised him to potentially apply to be removed from the pub watch ban, as I believe he had a verbal altercation with the barman and it didn't seem to warrant a ban as a one-off incident. So I've advised him to try and get that remedied. However, and most importantly, I would like to remind the committee that the police have absolutely no issue with the applicant or the application or associated parties. I'll briefly mention flat 2. The resident is concerned there that there will be noise from live music, quote, all day and into the early hours. Well, it's not going to be a live music venue. On the odd occasion, there is a band. It certainly won't be into the early hours. Nicola has got 2 young children and they intend to move above the premises to live. So they're not going to run a late night bar with loud music when they're living above it with 2 young children. So there are no concerns there. As mentioned already, the property has decent soundproofing. There will be no windows or doors open at the rear whatsoever during any regulated entertainment. I think the resident there, with respect, is concerned about what may happen due to their experiences with other licensed premises along that busy commercial street. However, there is no evidence whatsoever that any of these issues are connected to these premises. I've been as brief as I can, Chair. Those are the submissions on behalf of the applicant. I've got the applicant with me, obviously happy to answer any questions you may have.
Thank you. Any questions by relevant persons?
Yes, there is. First of all, looking in the amendment, I know you said that the back doors, etc., will remain closed. That isn't mentioned in the annex or anything. So if that could be sort of written in somewhere, just to ensure that the back door isn't open, and you know, because I mean the neighbouring licensing properties, they're not allowed to have their back doors or windows, etc., open during like entertainment and during opening hours. So I would we'd appreciate if that could be written in as well. Also, I am aware that Sue has actually spoken to Gary and Nicola about noise previously, so to say that there hasn't been no complaints is a little bit unfair. They did try to speak to them in person rather than sort of causing issues and minimising people, you know, sort of, you know, because we appreciate that they're a new business and trying to get running. You know,
Sorry, can I just interject? These are for questions of the applicant at the moment. You will be given an opportunity to run through your opening statement and say, so do you have any questions of what you've heard to the applicant? And then thereafter, you will be given the opportunity to outline what you want to say.
Yeah, so yeah, basically it's about things being put in about the doors being open. We appreciate that. If you know, if there wouldn't be any deliveries between certain times to respect the residents, that'd be fantastic. I would like to raise a little concern about there not being any door staff on till 10 o'clock on the evening. That does seem quite late. It says 22 hours in here. The licensed door supervisor will be on no later than 22 hours, which is 10 o'clock in the evening. I do feel like that's a little bit too late, especially if we're going to be serving alcohol all day. In respect for the, you know, when you're looking at public safety and things like that, I do feel like that's a little bit too late in an evening for that to be happening. And would also like to ask consideration if you would consider going on to the pub watch scheme, just to ensure public safety and, you know, against crime and disorder, because the majority of the pubs in the town centre are part of that scheme. They just seem to work very well together.
I know a number of issues have been raised, Chair. Perhaps you'd allow the applicant to address those in the questions.
Surely, yes.
Thank you. Thank you very much. Yeah, the back door, it's a cellar door. There's no customers coming and going. So we're happy for it to be a condition to state that during regular entertainment, the cellar door at the back that nobody ever uses won't be left open or wedged open. Happy, no problem at all. Door staff, yeah, there's a risk assessed door staff condition, very common amongst pubcos. It basically means that if there is a huge event going on in the town that starts at midday on a Saturday and goes through till midnight, as it's a risk assessed door staff, it allows the flexibility for the DPS to decide when to put the door staff on. The police are happy with that condition. The police are happy with the application. They've no issue with the door staff situation. However, it's deliberately worded as a risk assessed door staff condition rather than door staff will be on from 10 p.m. only. It's risk assessed. If the applicant chooses to have door staff on at 6 p.m. or midday, they can do, because it's risk assessed. They will decide whenever they want to have door staff, they will have the door staff on to cover events going on in the town. And as I say, the police are happy with that as well. So thank you. Thank you for the opportunity to reply to that.
Can I ask a question very briefly? You might have noticed that the last 3 days has been a bit on the hot side. Has this made a difference to the door opening arrangements?
Well, they're not open because we haven't got a license, Chair. So it's been running on temporary event notices just to. Yeah, the tens ended a month or so back, hence the application.
I don't know whether Chair, you're actually saying, are the conditions offered and are you able to adhere to them? I think is, you know, doors and windows being closed during regulated entertainment. I think what the Chair is alluding to is, is it something you would be able to comply with?
Absolutely, 100%. The conditions are very compliable. No problem at all.
Thank you. You state that no person under 18 will be allowed in after 10 p.m. unless supervised. So that's suggesting that you will be allowing under 18s in before 10 p.m. Is that the case?
Well, the idea is to provide food going forward. So there will be, it's not, the concept is going to be more of a daytime food venue. So under 18s will of course be allowed throughout the day.
So it's
And there will
more
be
of
the
a
odd
cafe
private
bar
party, the odd event.
still.
Yeah.
Yeah, okay. And also, second question, if I may, it's been mentioned that Mr. Archer, your partner, is on pub watch. Is he actually working at the pub, or will he be working at the pub, or is he just helping with renovations?
No, my partner did all the renovations on the property. That's what he does. That's his day job. However, when initially, as we have been opening on 10s, he has been around. He doesn't work the bar. He's been around if I've been there, but I haven't always worked it as well. But no, moving forwards, if we were granted a licence, he wouldn't be working at the venue.
Just following on from that question there regarding your partner, so he will have no role in the running of this business at all then?
Well, he's the partner of the applicant. He will be obviously in the background. He'll be helping out with any odds and sods and jobs going on around the business, but he's not front of house. He's not the DPS. He's not the applicant, and the police are fully aware of his association and are absolutely happy.
Yes, thank you. There's a section now for relevant persons to make opening statements and introduce witnesses.
Yeah, I mean, obviously some of the concerns that we have been sort of, addressed through the amendments and agreeing to have the door closed. I do feel like it's a little bit unfair to negate it all just as being a neighbourly dispute, because when they first moved in, and even when they had the first premises, my family did used to frequent their business. They had eaten at the previous business that they had and was willing to support it. It was purely through to, I'd say, poor management. You've been opening a business, albeit granted temporarily running, and there's no, bins was an issue because you have no bins for the premises, but we understand that's for a separate department, that's a separate issue. But previously, my mum has made a complaint about the noise directed to the applicants, and the response that she got from Gary was, well, we want this, we don't know what the DJ was doing. So that's not a responsible response when somebody's raising concerns about noise from the business. And while there is other businesses either side, they have a long list of stipulations to minimise the noise that's coming from their business. And actually, as far as it goes, they do sort of stick, to that. You look at Apollo, they've got a member of door staff. Yes, they have an outdoor area, but they have members of door staff stood there constantly that shut the door every time somebody goes through it. It's just used as a smoking area. There's no music played out there. You go to Garden, when they're open, they don't have the back door open when they're operating. Same as Goat, they don't have any opening windows at the back or a door. They do have a door, but they don't open it. So they do adhere to things. So the concern is about the applicant's ability to work to and adhere to the licence conditions. And also, will there be, and those businesses are quite, apart from Garden, which is close, they're not as close to the actual fronts of the flats as these other businesses. They are holiday homes, but they're private holiday homes, so they're not rented out. There's flat 6 and flat, what other number is it that live there permanently? There's 3 flats now that are lived in permanently out of the 6, and the other 3 are used as holiday homes. So it's just about being considerate to those that are there all the time. And, and most of them are, the retirees, they are elderly. And whilst they are living in a vibrant area and above businesses, a majority of the noise is just during the day. It's daytime noise. The business along the harbour, they're not open on a night. It's not somewhere that's loud noise. And when they first bought the flats, albeit one owner, there was no Goat, there was no Garden, there was no Brass Monkeys. It's not as though they knowingly moved into a place where there was a load of pubs. Like how many late night venues does there need to be on one street? Because anytime there is a disturbance is normally when there is fighting in the street. When so that's when the sort of the main disturbances do actually come for the residents.
Thank you. Any questions to ask?
Chair, does the other relevant person wish to speak and then questions after that?
Okay, do you wish to speak?
No, I think all's been said, thank you.
Thank you very much. Any questions now, please?
Well, I just would like to say, yeah, with respect, I wasn't playing down the neighbourly disputes. I was just suggesting that they're for a different forum. This is a licensing, and I was being a bit lory, but this is a licensing committee. And unfortunately, parking and bins and who puts stuff in a bin, unfortunately, isn't. That's all I was suggesting on that, because it's not a matter for licensing and this subcommittee. And yeah, I note that the Apollo, a couple of buildings along, literally just there, is open till 3-4 a.m. with a constant beer garden door opening constantly back forth all night, and it has very, very loud booming music on all the time. Thank you.
Thank you. And there's an opportunity to sum up if you wish to. You might.
Have any of the panel any questions?
Yeah, sorry, any questions from the panel? No more questions. Sorry, I don't do this very often. So there's an opportunity for summing up from the relevant persons, first of all.
I feel like we've expressed everything that we need to express. So we've not got anything more to say. Thank you.
Thank you very much. Okay. And any further points from the applicant?
Am I allowed to sum up now, Chair?
Summing up, yes,
Yeah,
please.
okay, thank you. I'll be very quick. Section 9.43 of the 182 guidance states that the authority's determination should be evidence-based, something highlighted in the well-known High Court case of Thwaite. So what is the evidence? Well, no objections from the experts and the primary sources of guidance in crime, disorder, noise and nuisance, i.e. the police and environmental health. In fact, there was in effect 2-3 relevant objections, and they were mainly involved with private neighbour issues such as the use of bins and parking, or they were concerned about what may happen in the future, as there are a few noisy bars in the area. As we've already seen, the robust, comprehensive conditions offered in our application demonstrate how the applicant takes the promotion of the licensing objectives very seriously. We've even offered an additional condition relating to one of the residents' concerns regarding delivery times for beers and collections, etc. The premises is to be run by an experienced local businesswoman who, with her 2 young children, intend to live above the premises. The area is a very busy commercial area in the centre with lots of noise and hustle and bustle day and night, and the application seeks a much reduced offering compared to some of its licensed neighbours. I'll finish by reiterating to the committee and the objectors that under the Licensing Act 2003, a local resident or anybody in fact can apply to have a premises licence reviewed if at any time after the licence has been granted matters arise that concern the failure to promote the licensing objectives. I conclude by thanking the committee for its time, and in light of what we have heard today, I respectfully invite the committee to grant the application. Thank you.
Thank you very much. Policy advice, I think, is necessary from the licensing officer.
Thank you, Chair. Just a few points, just to remind members, please. Conditions listed in the annex around public nuisance, where they are referred to regulated entertainment, members do need to be mindful that these will not be enforceable or have any effect during the deregulation hours. So mention's been made, for example, of the back door being closed for regulated entertainment. If that regulated entertainment is between 8 a.m. and 11 p.m, that condition is unenforceable. And therefore, it would only take effect post 11 p.m. each day. There was also a mention made around pub watch and whether that should be conditioned onto the licence. Members do need to be aware, if you are considering conditions around that condition needs to be very carefully worded in such a way that the licence holder can control that condition. So, for example, the pub watch falls away, they are become in breach of their licence, but not by their own fault. So therefore, it needs to be worded in such a way that where a pub watch would exist, that they would be an active member to ensure that that would be enforceable. The need has also been mentioned, and just a reminder to members that that is not a consideration under the Licensing Act, and therefore with us having no cumulative impact in policy in place, that is not something that you can consider today. And lastly, just a reminder that the tweaked conditions have been placed around today, and if members were minded to grant the application, that you would consider those small amendments to those conditions as proposed by a licensing authority. Thank you, Chair.
Thank you, Louise. Legal advice from the legal advisor.
Chair, some of the points have already been covered in relation to the Live Music Act and the deregulation issues surrounding those concerning the conditions offered. I think just to clarify, there was two additional conditions offered. One surrounding the cellar door at the rear to be kept closed during regulated entertainment. And obviously that would have the same effect as the other condition which has been offered in relation to the doors and windows to be kept closed during regulated entertainment. That would kick in from 11 PM as in relation to the same concerning the Live Music Act and deregulation. Obviously, mention has been made concerning reviews. Indeed, if these become problem issues, then it is open to responsible authorities and other relevant persons to bring a review. On review, any conditions imposed concerning regulated entertainment can actually come live. So essentially, regulated entertainment can be controlled during the day on review, and additional conditions in relation to that. Moving on, you've heard reference to other licensed premises in the area and their licensable hours and etc. and their conditions. Obviously, this application must be determined on its own merits on a case-by-case basis. The licensing officer has already covered the issue of need. That's not a licensing issue for you to consider, that there are sufficient licensing premises on this particular street. It should be, there isn't a cumulative impact policy in this area. So that isn't relevant in relation to that. You are given guidance within the director's report about nuisance and what that means. Reference has been made to other issues concerning bins, parking and ancillary issues. I draw your attention to the statutory guidance at paragraph 9.44. It reminds you within that condition that it's imperative that the authority ensures that the factors which form the basis of its determination are limited to consideration of the promotion of the licensing objectives and nothing outside of those parameters. So that's your focus today in relation to your determination. You're given lots of guidance in relation to, as I've mentioned, nuisance and conditions. Tweaking has been mentioned in relation to conditions offered. Obviously, in terms of any conditions, once they're imposed on a licence, they must be enforced, because breach of those conditions obviously is an offence. So I think mention was made of SIA door supervisors by both parties concerning, there was a concern that they're not to be, that they should be on earlier. And obviously you heard the applicant indicate, obviously it would be risk assessed. If a time is set when door staff must be on, then a licensed premises would have to adhere to that, because it would be a condition, and not complying with that obviously would be breach of a licence condition and would be an offence. I think that's all I can usefully add in terms of what the issues have been addressed. You are given guidance in relation to relevant sections of the statutory guidance within your report to help you in your determination.
Thank you. And thank you all indeed for your attendance this morning. I think we're now going to private deliberations.
And did you want to give an indication how long you think you might need, so that
It's always the difficult one.
Cup of coffee, or
It's always the difficult one, but let's say half an hour minimum. And if you have to leave because of other commitments, then we will write to you anyway.
then come back down to reception.
Thank you. Thank you all.